of the Judicial Council of Georgia. Just a little bit of background, and then thankfully those of you who have not met him already, this is our Chief Judge, David Sweat from the Western Judicial Circuit, and if I can answer questions that you might have about the operation of the court or the Judicial Council recommendation and the supporting information, I'm sure he'll be able to. But for several years, the Western Circuit has been on the approved list to receive an additional judgeship based upon the Superior Court workload assessment that the Judicial Council performs. Just so that you'll know, since the creation of the circuit's third judgeship in 1995, the population of the Western Circuit, which is Athens, Clarke, and Oconee County, has grown by 1/3. And so when the statistical analysis of the caseload was performed, it exceeded 4 judges. And just to let you know what those were, in 2011, 2012, and 2013, the workload assessments document a judge workload value of 4.69 judges, 4.16 judges, and 4.15 judges respectively for those years. So for some period of time, and in fact dating back to 2008, the Western Circuit has been on and off various lists, and then of course we had an economic downturn that necessitated the wait. But this year we are the only circuit on the recommended list, and at least as of this morning's subcommittee report, it is in the appropriations process already to be appropriated as of April 1, 2016 in the appropriations bill, as of the subcommittee report. So I know there's been some discussion about the start date, Mr. Chairman, in terms of whether it should be January 1st, 2016 or July 2016, which the bill states. But I just wanted to let you know that that is what is in the appropriations process so far.
So state that again. The appropriation you have currently in the 2016 budget provides for funding to begin as of what date? As
of April 1, 2016, and Chairman Atwood can correct me if I'm wrong, but I was paying pretty close attention to that, as you might imagine, this morning when the committee report was made and it was voted out.
So whatever we do needs to reflect the fact the date will be for the time beginning appointment by the governor. It says the term beginning July 1, 2016. Is that still a good date, or do we change that?
I think our judges would like the help. So if the committee would consider changing that to April 1, 2016, I think it would be very much appreciated and also match the appropriation.
So do I understand that the reason for a new judge is not just because Judge Jones left the bench and went to another court?
No, sir. No, sir. He was actually replaced by Judge Haggard, although he's irreplaceable in so many respects. I'll just state for the record. But Judge Haggard took his place. This would be for an additional judgeship.
All right. And I think we've had some discussion. Judge Sweat, do you have something you want to add to this?
Well, I just appreciate your support. I think that in the Western Circuit we have done as much as we can without getting another judge. We have been overutilizing our senior judge budget for the last 3 years. We get some senior judge money from the council, and we have exceeded that with all the requirements. We have 2 death penalty cases in process. More importantly, though, we have 3 accountability courts. Each of our judges has responsibility for accountability court, a felony drug court. I supervise a mental health court, and then Judge Haggard supervises a veterans court. Is there a
state court?
We have a state court over there, and Judge Oslander, Judge Simpson, and they have really one of the first DUI drug courts in the state of Georgia, back from Judge Lawrence.
You got 2 judges there.
We have 2 judges there. Our caseload is driven in large part by the significant criminal problems we have in Athens. It has a profile of being a pretty, despite the university being there, we have an extremely high poverty level, and that has driven a lot of serious violent felonies, and that has caused us a lot of our work. And those cases have gotten backed up. 4%, 4 judges. If you go after with that for a while, you just can't clear all the cases.
Yes.
It just takes a while. So we would appreciate some assistance.
I know Mr. Jacobs been working with you on some language, and I'm going to ask Mr. Jacobs, there you are, if you'd like to address what is the issues we have now. Is that number 14? That's yours?
Yeah, my microphone's on now.
Excuse me.
Yes, Mr. Chairman. In subcommittee, we had discussed with Judge Sweat the method of selection of the chief judge of this circuit, and the method that was in the bill as it came to us had the senior judge serving as chief, which is not the way they do it in the Western Judicial Circuit. In subcommittee, we just stripped that language out in its entirety, but on the always wise and appreciated counsel of Ms. Travis, it would be advantageous to have specific language in the bill creating the local law that governs how the chief judge of the circuit is selected. So met just a little while ago with Judge Swed and Representative Quick and came up with some language that's been handed out to everybody that would provide for the election of the chief judge by the judges of this circuit, and at the appropriate time I'll move that amendment.
Ms. Quick, you want to add anything further?
No, sir, Mr. Chairman. I appreciate Chairman Jacobs' work, and of course appreciate Ms. Travis looking out for the fact that judicial turf wars may break out in the Western Circuit like we've never seen before, and providing for that contingency.
She and I can tell you, I've seen them around the state, and they're not pretty.
We don't think of such things, Mr. Chairman, but I appreciate her looking out for us.
You never know what's going to happen. And I believe Ms. Evans.
Thank you, Mr. Chairman. This is a question about the amendment language, so I don't know between y'all or Representative Jacobs who would be best to answer, but the second sentence reads, in the event of a tie vote, the judge most senior in point of service shall be the chief judge for the ensuing term. And I'm wondering if the intent is that regardless of the two people that were tied, the judge most senior, or as between the two judges that are tied. I'm just thinking we might need to tighten that language up.
Well, with 4 judges we'll have 4 judges in the circuit, and you could theoretically have a tie. I don't know that we had we have not really thought about having this sort of a circumstance come up. So, if there's suggestions, I think I think we'll be able to work with this language, and it just the I don't think it's going to be that level of contention.
Oh, I don't suspect at all. But if we're going to put language in, you always have the rule book or the agreement in the event of the circumstance that you never anticipate. And so I just think it needs to be clear if we're talking about of everybody, it's going to be the most senior, or as between 2 judges, because I don't think that's clear. And I can propose some language unless Mike comes up with something between now and then.
All right, what we'll do is, if there's no one else to speak on the bill, I'm going to close off public input, but I want you to remain, if you will, because we're going to get in this amendment and maybe questions that you'll need to respond as a part of the committee. Mr. Jacobs, why don't you talk about your proposal? Let's do this first. The chair will entertain a motion on House Bill 367. Motion is due pass. Are there any amendments to the motion? All right, Mr. Jacobs, present your amendment, please. Excuse me.
And let me first ask the chair, would you, if we were to add language to this amendment, do you want to do that as part of the amendment, or do you want me to propose an amendment to the amendment?
I think you will be proposing an amendment to the amendment. We'll take an amendment right now.
All right. So, well, I'll move the amendment that's printed and handed out to everybody.
And that's LC 296427S, Amendment HB 367. Okay. It addresses Section 7.
And
do we have a second to the amendment?
Second.
It's been seconded. All right. From that, do we have any further amendments to the amendment?
And then I would move to amend the amendment by inserting after the word judge on the second line, in the event of a tie vote, comma, the judge nominated for the position most senior in point of service shall be the chief judge for the ensuing term.
So you add in nominated for the position.
Correct.
And then continue on with most senior in point of service shall be the chief judge for the ensuing term. Is that correct?
Correct.
All right, let me ask you another question. There any further discussion on that amendment? And there's been acceptance of that amendment?
I'll consider that a friendly amendment to the amendment, Mr.
All
Chairman.
right, there was a second. The last line, I think we had some discussion about this, is that the chief judge shall be eligible to succeed himself or herself. Then it says for one or more additional terms. We talked about limiting that to 2 terms, which would be a total of 4 years, and then there'll be required some rotation within the other judges. Is that something that you desire to see as a part of it or not desire? I know you don't have any input, but I suggest it's good practice, again, for the reason it brings in new ideas, new approaches, and it's really a burden that the chief judge carries. That sometimes it's good to, let's say, let's pass that burden on to someone else after 4 years of it. I'm proposing an amendment to your amendment, which would be as it says, strike out or more additional.
Or we could just say,
or more, excuse me.
The chief judge shall serve no more than 2 consecutive terms.
All right. So after shall, you're going to just strike out the whole sentence, insert shall serve no more than
Or actually, Mr. Chairman, let me pull that amendment back.
You can tell them we did this.
Chief Judge. I think it would be sufficient to say the Chief Judge shall be eligible to succeed himself or herself for 1 additional term.
Like I was saying. Okay, so we'll strike out or more and take the S off a term. Correct?
Correct.
All right. I would propose that as an amendment. It's been seconded. And I'll start now with, we've had a second on the amendment. We will talk or vote as to these 2 specific amendments. The first amendment is on the second line after judge, inserting nominated for the position. So it reads, in the event of a tie vote, the judge nominated for the position most senior in point of service shall be the chief judge for the ensuing term. Any further discussion on that amendment to the amendment? The chair will call the question. All in favor signify by saying aye.
Aye.
All opposed, motion carries. Second amendment to the amendment is to have struck on the last line or more, and after term take off the S. So that will read, the chief judge shall be eligible to succeed himself or herself for 1 additional term period. That is the motion, correct?
Correct, Mr.
Any discussion on the motion? Chair calls the question. All in favor of the second amendment to the amendment signify by saying aye.
Aye.
Opposed, like sign. Motion carries. We'll go back to the amendment as amended. This is we'll call it the Jacobs Amendment. There's any further discussion on the amendment as amended? If not, we'll call the question. All in favor of the amendment as amended, signify by saying aye.
Aye.
Opposed, like sign. Motion carries.
One further amendment, Mr. Chairman.
Yes, sir.
On line 22 of the bill, strike July and change it to April.
All right. Do we have a second to that? Second. Motion's been seconded for amendment to line 22. Any further discussion of the amendment? Now, the chair will call the question. All in favor of the amendment signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Any further amendments? We will now vote on House Bill 367 as a committee substitute as amended. All in favor? Any further discussion? There being none, the chair calls the question. All in favor of the motion to adopt signify by saying aye.
Aye.
Opposed, like sign. We've got your bill.
Thank you, Mr. Chairman.
Thank
We
you very
appreciate
much.
it.
Thank you very much. We appreciate it.
You're welcome to stay and enjoy the rest of the meeting, too.
Well, you know, I love the discussion of forfeitures, and I know that's going to be very exciting, but I'm just going to wait until that's coming to a courtroom near me.
Okay.
And it will be good. That's what I'm thinking.
Thank you,
y'all
Mr.
very
Chairman.
much.
Thank you.
Thank you, Jim.
Now, your people have not arrived yet, have they?
No, Mr. Chairman.
We'll hold up. We got Mr. Dollar here now. Representative Dollar, you want to come forward on your bill? This is a bill that did not go through the committee process. It was a bill from last year that had been considered by us. We're looking at House Bill 245. You might give Mr. Dollar the history on this and speak to the purpose of the bill.
Thank you, Mr. Chairman. As you stated, HB 245 is a measure that came through this committee last year. I believe it was somewhat of an anomaly that it didn't even have any questions. It's a pretty simple measure. What it does is it allows condominium associations to change their what they can do for special assessments from 200 to 1/6 of the condo's yearly dues. Georgia is the only state in the country that places a cap on such assessments by condo associations. The cap was imposed about 25 years ago, and based on current rates, CPI rates, that amount would be roughly double what it was then. The impetus or reason for this bill is condo associations, they have to do certain projects, and to meet those needs, what they do is they keep increasing everybody's dues instead of just these one-time fees. The bill passed again out of the committee, passed the House floor. Just ran out of time at the end of the year, as many of these measures do. I'm happy to answer any questions from the committee.
Questions? Let me ask one thing, Mr. Dollar. The dues versus assessments. Mm-hmm. Is this dealing with just the assessment portion of it, or is it talking about dues being increased?
It has nothing to do with dues. It's just about assessment.
Assessment.
And it's for small projects. This still empower the condo associations currently have the power to do large projects, but those require a 2/3 votes of the owners.
So this allows the board of directors on a small project to say we got to make an assessment. It may be paid out over a period of a year or 1 month. We don't know, but they could do that with this language.
I own a condo, and every year that I've owned it, my dues have gone up, and this is an effort to try to,
Gotcha.
wane that back some.
Any further questions of Mr. Dollar? If not, anyone wish to speak to House Bill 245? I think we had somebody on the sign-in sheet. But come have a seat with Mr. Dollar if you like, and give us your name and who you represent.
Hi, my name is Lanier Coulter. I am the chair of Georgia's Community Association Legislative Action Committee with the assistance of the committee last year, as Representative Dollar pointed out, and Representative Dollar. We believe this bill is twofold, everything that Representative Dollar mentioned, but also we're moving away from these hard dollar amounts in statute because, as we see, 25 years later, they don't make a lot of sense. So we think this bill will serve that purpose, and I'm happy to answer any questions about it, but I do believe Representative Dollar has covered it all.
Thank you, Mr. Coulter. Anyone have questions of the presenter, Mr. Coulter? If not, anyone else wish to address the committee? If not so, we'll close off further public comment. The bill is now in the breast of the committee. Do we have a motion?
Do pass.
Motion is due pass on House Bill 245. Do I have a second? We have a second. Is there any further discussion on the motion to do pass? There being no further discussion, the chair calls a question. Do pass House Bill 245. All in favor signify by saying yea. Yea. Got you that time. Opposed, like sign. The bill passes. Thank you.
Thank you, Chairman. Thank you, committee.
Thank you.
Mr. Atwood, I think we can go ahead and start your presentation, and they can come in, and we can have others also speak to the bill as they arrive. We're calling on, the chair calls House Bill 233. Presented Mr. Atwood. Why don't you come on around here where you can be by the mic?
Oh, okay.
Might be a little easier for you.
Thank
Well,
you.
I'm pretty loud, as you know.
I remember.
Thank you, Mr. Chairman and members of the committee. I present for your favorable consideration House Bill 233. And this is, Mr. Chairman, is essentially the same as it was with a few minor changes. I have got Mr. Gary Bergman of the Prosecuting Attorney's Council. Also, Mr. Frank Rotunda with the Georgia Association of Chiefs of Police could not be here, but wanted me to communicate to the committee that his association supports this legislation as currently written. And I believe I can speak for the Georgia Sheriff's Association as well as Prosecuting Attorneys Council that they support it. We already have a letter from the Prosecuting Attorneys Council. They were supposed to be here, but they're tied up.
I ran into them.
They're tied up in Mr. Pack's committee. And I don't know if we have anybody that was not on the committee last year, but at the end of last year's session, I was asked to carry by the chairman. And Mr. Chairman, I want to thank you for the hard work that you've done. This would have never happened, and this bill would have never happened if you had not had the foresight to put this very complex legislation together. And I want to say that publicly to you and the good hard work you've done. All I did was
Thank this lady over here who did most of it, Ms. Travis.
And Ms. Travis.
And I would say if I had to go to the dictionary, look under the term Solomon, I'm sure I'd see your picture.
I think absolutely we would, and Ms. Travis has done a very, very excellent job.
She sure has.
As we know, civil forfeiture provisions are currently spread across some 34 separate code sections. They encompass about 14 different procedures, which alone, I think, cries for some consolidation and standardized procedure. And what this bill essentially does is it brings some due process a little bit more. It puts some rules in place. It puts reporting in place. And the only changes that were essentially done is we redefine the definition of official law enforcement purposes, and Mr. Bergman can speak to that. We clarified and limited the manner in which the forfeited assets may be used. We created new definition of official prosecutorial purposes, which also clarified and limited, more importantly, the manner in which forfeited assets may be used. We required a uniform reporting for prosecutors and for law enforcement, and established that all the reports shall be filed on or before January 31st for the previous year. The Prosecuting Attorneys Council is going to create the form that law enforcement agencies, DAs and state agencies use, be uniform for. We established the minimums of what has to be reported, and we reduced the duplication of effort by prosecutors and law enforcement. The DAs are authorized to investigate, to ensure compliance with use and reporting of forfeited assets, which I thought was important, and we provided for a review of the district attorney's use and reporting of assets. I was on part of the study committee, but I also worked, as you know, for many, many years as a federal agent. I was one of the guys we called out in the middle of the night. We worked under serious rules, and I think it's very important that all of us do. And with that, I will open up for any questions for the committee, or turn it over to Mr. Bergman for
Why don't
more
we hear
specifics.
from Mr. Bergman?
Yes.
And if he go through and talk of the things that were changed. So I know last time the bill addressed like a trust fund being established.
We did have a trust fund,
Go ahead. You got
Mr.
the
Chairman.
microphone.
We have done away with the trust fund. However, the ideas that were incorporated in the trust fund are now put back into the statute. In other words, the money would have come to the Prosecuting Attorneys Council, and then it would have been sent back to the DAs. What we've done is we are allowing the money to go, as it has always done, to go directly to the DAs. However, the DAs now have very specific reporting requirements. We will create the forms by which they will report. The DAs will have to report not only to the Prosecuting Attorney's Council, but will report to the state auditor and will report, send the report to the Carl Vinson Institute. If the state auditor finds a problem with anything that the DA has done, they are required to notify the Attorney General, and this statute gives specific ability to the Attorney General to take whatever action they can. That being said, really the AG always had that ability under our law, but this makes it even more so. Okay, it specifically spells it out.
Yeah, I didn't mean to interrupt you. You want to go through your presentation?
I can talk about all the things that we have done over the last 3 years, if you would like.
How far in depth do you want to go? This question. All right.
Well, first of all, as Representative Atwood said, we're standardizing the procedure to be used in all forfeiture cases. We had tremendously different procedures. We had 34 different. We had some that didn't have any procedures at all. We're using the well-known procedure of 161349 instead of creating a new procedure. We have tweaked 1649 quite a bit, but it's basically the flour for the cake. Okay, it may have been a different type of cake, but it's still basically the same flour. We're providing greater notice to owners of seized vehicles. It requires seizing agencies to make reasonable efforts upon seizure to determine registered owners and inform the owners of the seizure. That is not under current law. We're providing greater access to courts for claimants. Under our quasi-judicial forfeiture provisions, any timely claim received by the DA will trigger a requirement of DA to file a complaint for forfeiture. I think that this legislature was very concerned over the last few years with the gotcha aspects of the bill, especially when you had non-lawyers filing claims. This provides that if you send something in, it doesn't meet the statutory requirements in a quasi-judicial forfeiture. If the prosecutor gets it, they are statutorily required to go ahead and file a complaint for forfeiture and bring it to the court. There'll be no gotcha. It establishes a procedure for challenging this insufficient answer to a complaint. So there is a procedure in place where the state would have to file a motion for a more definite statement, give the person the opportunity to fix whatever the DA says, your answer is insufficient, and to give them the opportunity to do so before their complaint gets dismissed, or before their answer gets dismissed. We clarify that if discovery is allowed, it shall be on a reciprocal basis, and that the court shall control the duration and scope of discovery. 161349 doesn't have discovery procedures at all, and it's sort of a halves as half can. So this sort of gives them the opportunity to the court the opportunity to say, we don't need discovery in this case. We do need discovery. You can have 3 months. You can have 2 months. You can have the full 6 months. It's that big of a case. Okay. We explicitly provide that forfeited assets are government property and requires the transparency. All forfeited property is subject to normal accounting and auditing requirements applicable to state and local governments respectively. We redefine, clarify, and limit the manner in which forfeited assets may be used. As Representative Atwood said, we define official law enforcement purposes, and now we've created under this one an official prosecutorial purpose, and we specifically define what are those purposes. We have strengthened and expanded the annual reporting requirements. We're requiring law enforcement agencies, DAs, and state agencies that receive forfeited assets to maintain records and make detailed reports by January 1 for the previous calendar year that shall be available for public viewing. Under the bill as it existed last year, it was during their fiscal year. And, of course, not everybody had a fiscal year at the same time. Some would have calendar year, some would have January 1, or some would have July 1. What we've done here was we've uniformed it. We said you have to report by January 31st for the previous calendar year. So everybody's going to report at the same time. Everybody will be able to see all that. You won't have to say, well, when's the last time you reported? Okay. We've required uniform, like I said, we've required uniform reporting. With district attorneys specifically authorized to conduct the investigations to ensure compliance with use and reporting of forfeited assets. The DAs may bring criminal prosecution or civil actions to enforce the use and reporting requirements mandated under the Act. We provided for review, like I said, of the district attorneys by the AG's office. And finally, the failure to abide by the use and reporting requirements will result in a prohibition of eligibility to receive forfeited assets. That is something that was carried over from previous years, but we've kept it into this bill. So I think generally we've expanded the rights of claimants. We've expanded the transparency and the use of assets, which it was a concern in previous years. I'm sure it's still a concern this year. And I think overall the bill is a very good bill and does what this legislature intended when it started out drafting this back in 2011.
Thank you, Mr. Bergman. Any questions of the presenters, members of the committee? Yes, ma'am.
Hi, thank you. And I was trying to write down my questions so I sounded somewhat intelligent before I asked. Does the bill address specifically the ability for a law enforcement department to forfeit property under the drug statute where drugs are not located in the vehicle? So, for example, or in the process. Example, I had a client who was stopped on the highway, no drugs in the car, but because of the amount of cash they had, they said, well, we believe this was drug funds, and it seized.
I know what you're saying. No, the bill doesn't say that. I mean, we still have the requirements of 4 ounces or less or more of marijuana, 1 gram or more of cocaine. That is not specifically mentioned in the statute. You still have to have a preponderance of the evidence to prove it. Merely having money in your car without the other evidence not going to get you a forfeiture. And of course, like I said, there are greater abilities of claimants to file their claims if such a thing occurs, and the state can't simply just forfeit it when somebody comes in and says, I want my money back. You took my $10,000, and it's a person that doesn't have a lawyer. It's going to get filed in court, and so a judge will be reviewing those type of things.
I might follow up just saying it doesn't change the standards under which the police operate with going through a seizure of property that may be subject to forfeiture. What we set out here is now an appropriate procedure that will be followed by law enforcement that has obtained property as a part of seizure, which is different from the forfeiture. And this is going to be the forfeiture proceedings where your client has a good roadmap to follow about getting his money back or her money back.
Mr. Chairman, if I could also add to the representative's question, I have had a tendency to focus a little bit on the law enforcement side and their support. I have never, in my short legislative career, had so many divergent groups supporting and giving positive comments from the Institute for Justice as well as even the ACLU and even some Tea Party groups that have come out realizing the need and giving positive comments to us for it.
I think it's great improvement.
Yes, ma'am.
Thank you.
Thank you.
Thank you, Ms. Jones. Anyone else have questions of the presenters? If not, we appreciate it. I know there's some others here. I saw representatives of the Sheriff Association. Ms. Sills, you going to speak?
I am, sir.
Thank you. Please,
Mr. Chairman,
please do
if I
come up
could,
here.
before I get up,
Yes, sir.
I was
You wanna sit with Mr. Sills?
lacking in when I thank the chairman, but also the members of the committee and the study committee. Several of you were on that with me, and thank you for your hard work, too.
Thank you. Sheriff Sills.
Thank you, Mr. Chairman. I just want to
Always
say
good to see
that
you.
we have worked with Representative Atwood. It has been a pleasure to work with him. He has worked with us and the district attorneys on this bill. And I can say that the sheriffs of Georgia wholeheartedly support this bill as it is
Well,
written.
that's nice to hear. That's good work for everybody. Good work for everybody, Sheriff.
Thank you
Hallelujah.
all so much.
Well,
If there's
thank
any
you,
questions.
and appreciate your input and work on the bill, too.
Thank you so much. I'm
It's good to
back
have the
across
comments.
street.
Thank you,
That's
Sheriff,
fine.
for coming over. I know y'all been over there. Yes, sir.
Good to see you again, Sheriff.
Yes, sir.
Mr. Norris and the other gentlemen, thank you for all coming.
We're going to go back. Thank you, sir.
Pleased to see you. Is there anyone else who would like to speak to the committee on House Bill 233? If not, the chair will close off further public comment. Do we have a motion on House Bill 233?
Second, Mr. Chairman.
Motions do pass with a second. You've heard the bill presented with various parts of it. Is there any further discussion on the bill and the motion?
Jill.
Yes, Ms. Travis. Okay. Well, I hate this stuff. 81.
Page 81 at lines 2853 and 2854, and at line 2859, that and chapter 16 title 40.
Let's see what I'm coming up. Hold on. You're faster than I am. 81. What paragraphs now?
It's on line 2853 and 54,
All right.
and on line 2859 where it says and chapter 16 title 43.
Yes.
We repealed that chapter last year in House Bill 50. So
All right. So we are no longer looking at Chapter 15 of Title 43. I'm sorry, Chapter 16 of Title. That no longer exists?
correct.
Okay. Anything take its place, or do we need to?
No, it's all gone.
It's all gone. All right. So what we're doing is striking out on line 53, 54, the phrase, and Chapter 16 of Title 43. Leaving the comma there, right?
That's correct.
And then on lines 59, we're striking out and Chapter 16 of Title 43, but leaving the comma there. That would be a motion from the chair. The chair has got a second. Any discussion on the motion? Yes, sir.
Thank you, Mr. Chairman, and I just want to make sure my assumption is correct. This has no impact whatsoever on the substance of the bill by doing that. Okay, thank you.
All right. Any further discussion? Now, the chair will call the question on the amendment. All in favor of the amendment as stated, signify by saying aye. Aye. Opposed, like sign. Motion carries. Any further amendments? No. We'll go to the main motion, which is the motion do pass as a committee substitute as amended. All in favor of the motion, signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you for all your good work. Mr. Bergman, it's a pleasure to see you again. We don't see you enough. All right. That takes care of our 3 bills for the day, I believe. Is that right? Anything further business to come before the committee? If not, we'll stand adjourned. Thank you. Thank you all.